Winning in court. All these courts are privately owned trading companies. The United States District Courts are all owned, those are your Article I courts. They're all owned by the United States Attorney's Executive Offices out of Washington, D.C., which is a privately owned corporation. They're Article I legislative tribunals. They're not courts. They have a DUNS number, they have a PIT code, SIP code, NAICS number. You have to have that number in order to trade internationally. All these courts are registered with the DoD, Department of Defense. They have a DUNS number, which is Data Universal Numbering System. That's a Dun & Bradstreet. You have to be registered with CCR, Contractors Central Registration under the DoD. They have another department called the DLIS, Defense Logistics Information Service. The DLIS issues a case code that's spelled CAGE, Commercial and Government Entity, which corresponds to the bank account. They have a bank account. They take everything that you file into the court and they securitize it. And these banks and all these banks are registered, they have a depository agreement, a security agreement and an escrow agreement. And most of them are registered with the Federal Reserve Bank of New York City. And they use what they call. North Carolina uses a Circular 16, which they use as their depository agreement. They take public funds and they deposit them under it's called a depository resolution agreement. And they have a security agreement which the clerk of the court signs with the bank. And they have an escrow agent that acts as the go-between the Federal Reserve Bank that they have the account with, so all these courts are taking your money and funneling it into an escrow account. Most of them are in New York. There's $60 trillion of your money in the Federal Reserve Bank of New York City. And they've told the courts not to rule against the banks on these foreclosure cases. They're all in bed together. And what these lawyers are doing is acting as private debt collectors. And under the Debt Collectors Practices Act, it's called the FDCPA and it's Title 15 Section 1692. In order to be, when you're a public debt collector you have to be registered with the government, and you have to have a license and you have to have a bond in order to collect debt. Well, these attorneys are what you call private debt collectors and they don't have the attorneys are exempted by the Bar Association on that provision, but their firm is not. The firm they work for has to be registered and they have to have a license and a bond and they don't. And all these court cases that you're involved in, these attorneys are acting as private debt collectors. And what they're doing is collecting money from you as private debt collectors and they're not licensed or bonded to do that. And they do this through what they call a warrant of attorney. Black's Law Dictionary of 1856 defines what a warrant of an attorney is. It's like a writ of execution. It's like a put or a call. When you do a margin call, that means they use it to buy equity securities. 'Cause they securitize everything that you file into court, which means they turn it into a negotiable instrument. Then they sell it as a commercial item. They call them distressed debt. These debt collectors, that is what Unifund is, they come in and buy up all these court judgments as distressed debt. Then they put them into hedge funds and they sell them to investors globally. And of course, when you get into selling debt instruments you're creating a security risk. Anytime you get into risk management you have to have reinsurance. That's where Lure Hermes comes in. They're an underwriting company. And they're a subdivision of Allianz SE out of Munich, Germany. And they're the U.S. agency that acts as a bondholder for Allianz SE is PIMCO Bonds who takes all your securities, they pool them, and that's what they do on these mortgage loans. Go to their website and it'll tell you that's what they do. All of your mortgage loans are securities. The notes have a maturity of more than 9 months so they're a security by definition. If you go to Title 15 Section 77A(b)(1 it tells you that any note with a maturity of more than 9 months is a security by legal definition and an investment contract. So when you sign and endorse these notes as the drawer and the maker you're in an investment contract. And you gave them security. They take the security and they securitize it. As soon as they securitize it and endorse it for payment, they've securitized it. The loan is no longer secured. They've collapsed the trust and there's no corpus in the trust under probate law. And what they do is sell it as a mortgage-backed security. Well, PIMCO takes the mortgage-backed security pools over and sells them as bonds. So bonds actually come from pooled securities. And they sell these on the TBA market globally. And all these courts are involved in that. And the only time you can stop them is when you make them liable, and that's what I've been doing. I do a letter rogatory, which is a letter of instruction under the Hague Convention. And it's under Title 18 Section 1781 and Federal Rules of Civil Procedure, I believe it's 28B. And you tell them what you want them to do. You make a contract with them. When you go into these courts, you contract with them. And they run the courtroom.
Check out our packet in our email in the description. Our goal is